Welcome to Notable Approvals. I am attorney Amanda Shaffer. Today is October 1st, which means if you won the H-1B visa lottery and your I-129 petition was approved, today is officially the start of your H-1B status at work. So congratulations. And in light of that, I'm going to talk about another H-1B case today. It's a H-1B and also H-1B and a green card case. But this is a case that goes back all the way to 2011, this client. And it's notable for many reasons. One being that this client has been fought by USCIS at every step along the way. And despite all of that, he is going to have a green card soon. So let's take a look at why they were fighting him and how we were able to fight back. So this client's a native and citizen of Ecuador. He initially entered the U.S. on F1 student visa. He got his bachelor's here, he got his master's here, and after his master's, he was on his OPT. And he then applied, his employer applied for his H-1B as a logistician. I hope I pronounced that right, in 2011. And that's when he got his first RFE, or request for evidence. And in this request for evidence, this is a very common request RFE that we get for H-1Bs. USCIS said they don't believe that the logistician is a specialty occupation and that a bachelor's degree or higher is not needed to do this job. Another thing that is also common that happened with this first RFE is that the company he worked for was just him and his boss. It was a small company. So whenever you have a small company, USCIS tends to give smaller companies a harder time than bigger companies. So they said that they didn't believe he was only going to be doing the job duties we said, because since he's the only other employee, he must be doing other mundane tasks that you don't need a bachelor's for. So we applied to the RFE and was approved in January of 2012. After it was approved, he and his wife, whose status was changed to an H4 as his dependent, went back to Ecuador for a vacation. And because he changed status in the US, he didn't have a physical visa. So in order to come back, he had to go to the embassy down in Quito and get his visa stamped. So it was a few months after he took a nice lengthy vacation. When he went there, the embassy didn't believe he was still working for his H-1B petitioner company. And they would refuse to give him an H-1B stamp. Now, you might be wondering how common is it that this happens? I couldn't tell you off the top of my head, but for sure that this can happen and does happen, because every time you re-enter the U.S., you have a risk if you're not a U.S. citizen, but the risk decreases a lot if you're a permanent resident, that they might not let you in. If you're entering with a visa and your stated purpose for entering, if they don't believe it's the same as the reason you have a visa, you might get denied. So this client ended up staying in Ecuador for a couple of years almost, and then finally reapplied for a B2 visitor visa and came back to the U.S. When he got back to the U.S., he ended up getting another job offer with a different employer, this time as a network systems administrator. Since he had already applied for the H-1B lottery, already won the lottery, you don't have to reapply for the lottery. So we were able to file a new H-1B petition for him. And this was I think the only filing we've ever done for him where we didn't get a request for evidence. And that's because, like I said, as I said yesterday, if you watched the notable approval, that when you're dealing with computer professions, especially, this was before that even, this was an issue, but now small companies, computer professions, USCIS gives a lot more scrutiny and makes it a lot tougher. So this one, H-1B, got approved in just a couple of months. So that was in 2014, so he changed his status. And again, this was a small company. It was him and his boss were the only two employees there. In March 2016, his employer decided that he was going to sponsor him for a green card because, of course, an H-1B is a dual intent visa. So you can adjust your status to a permanent resident if either through marriage or through work if your employer sponsors you. It is a complicated process to do it if your employer sponsors you. So, and I'll talk about that a little bit. So the first step in the process, you do a prevailing wage determination. Once you get a prevailing wage determination is in your area, in your profession, at your level that the position, at your skill level, the position's asking for, you have to show USCIS, or actually it's Department of Labor at this point, that what the prevailing wage is for the equivalent position in the equivalent, with the equivalent background in the equivalent profession in the equivalent area of the country. So you do that, that's the easy part. Then you have to do what's called a labor certification. And this is also with the Department of Labor. And this part requires you to do all these job recruitment steps, which are, there's a lot of them. You have to do a bunch of different things. So basically you have to show that you could not get a US citizen to do the same job, that you actually went out there, tried to recruit US citizens to do the job, but you couldn't find anybody to do the job. And you only have a certain time period that you can do the job recruitment in. If you don't do it all in that period, you got to start from the beginning. There are very specific requirements. So when you fill out the labor certification, you have to write the dates that you posted postings, the websites that you posted them. You have to file in the newspaper. You have to put the newspaper, the dates, and you hold on to all the job recruitment evidence, but you don't send it in unless it's requested. And it's requested in something called an audit, which is kind of like a request for evidence, but they call it an audit. Audits are common with small companies. So we submitted the labor cert after doing the job recruitment in March 2016. And then in July 2016, we got the audit request. So we had to put all the job recruitment evidence together and send it in. And we did. October 2016, the labor cert gets denied because apparently one of the requirements is that you post at your office that you're recruiting for this job. And that the qualifications are for that position has to match every posting. They all have to be the same. So you can't say you need a bachelor's degree in the newspaper, but at work you post that you need a master's degree, because it's there to let other employees know internally that they're looking to hire for this position, and that so they can apply if they wanted to. In this situation, my client was the only one at the office, so it was, we weren't as concerned about what was going on at the office with this posting, but the job posting that we had to take a picture of and send in showed that the salary was rounded up. So it didn't match the salary in the rest of the posting, so it was denied. So because he was denied, his H-1B was going to be expiring soon, so we had to file to extend his H-1B. Luckily, if he still had time left, because you could only really be on an H-1B for 6 years. But he still had time left because of that time he spent outside the country does not count towards your time in status as an H-1B. So we refiled for the extension of the H-1B in 2017. And of course, we got an RFE. This time, the RFE said that we don't believe this is an entry-level job. Now, remember, he's been working at this position for 3 years now, and they know that it's the same job. They didn't think that all the duties he had to do were entry-level. So we had to reply to this thing and explain, like, look, this guy's a network systems administrator. To do this job, the entry-level job, you have to be able to do complicated things. And they actually pointed out certain job duties that we listed. They're like, this is an entry level. Well, no, that is entry level for this job. I could see in another type of position it wouldn't be. So we gave them a nice explanation of everything, and we also submitted the ONET summary, which, if you watched yesterday, I explained that ONET is a website that's private, but is sponsored by the Department of Labor and gives you all this information about all these different professions. We gave them more job postings that were similar to show that, look, this says entry-level network systems administrator, and the job duties are almost the same. We got an expert opinion letter, and then we also showed the petitioner organizational chart to show that it's not like he's supervising all these people and the job is different than we said. While that was pending, we filed or actually, I'm not sure when that was approved. We did get the approval. I didn't write that down. So we did get the approval for the H-1B after we extension after we replied to the RFE. So we then refiled the labor certification in June of 2017. And that meant we had to redo all of the job recruitment steps, the newspaper postings, the job postings, the office posting, all of that. In March of 2018, the labor certification was approved, finally, which meant we can now move on to the next step of the process, which is filing the perm petition. And in this case, we concurrently filed the I-485, which is the adjustment of status application, since the visa number was current. If you're not sure what I'm talking about, this applies to certain family-based and employment-based visas that you have to go to the visa bulletin, which changes every month. And there's a limited number of visas that can be given each year for certain categories. And if your visa number is current and you're in status in the US, then you don't have to wait for your petition to be approved. You can file it with the green card application. Otherwise, you get your petition approved. And then if your status expires that you're in right now, you have to leave the US and finish up consular processing in order to get the green card. In this situation, we first filed his I-140 as an EB-2, which is a member of a profession holding an advanced degree because he had a master's. That was in May 2018. In January 2019, without even an RFE, it gets denied. And we look at, well, why was this denied? There was issues with the qualifications or something. Basically, USCIS said, yes, your client has a master's degree, but the employer didn't want to make the master's degree requirement for the position because he didn't want to pay the guy more money, and he couldn't afford to pay the guy more money because it was a small company. So he said that if he would have said the entry level, the minimum requirement was a master's, the salary would have had to be higher based on the prevailing wage. So he's like, look, I can't afford to do that, or it's either I can't sponsor him then. So he had the master's degree, and then USCIS denied it because, even though he had the master's, because the job position that was being offered didn't have a requirement of having a master's. So in March 2019, we refiled the Form I-140, but we were able to do it as an amended petition, which was very fantastic news, which meant that we did not have to go redo the labor certification, which means the job recruitment steps, and we didn't have to start over with all of that. And the I-485 application was not denied. It was still pending. So because we filed the amended I-140 before the I-485 was denied, it kept that open, and we didn't have to repay the filing fee and redo all of that. So that was in March of 2019. In October of 2019, we get another RFE. This time, they're saying that my client did not have he was not qualified. Oh, he gained his experience in the job that he was at, so he wasn't qualified for the job. And because they can't count the experience he gained at his current position, even though it was the same position his green card was being based on. It's a little confusing. A lot of this is like circular logic, but essentially they're saying, you're saying, we don't believe he's qualified for this position, even though he's been working here for 3 years in the same job with the same requirements that you submitted that for this H-1B extension that was approved last year for the same level, everything. So we had to reply to the RFE, and we sent in an updated resume, his transcripts, and we were like, look, his education alone qualifies him for this position. He learned what he needed to do this job from day one there. He couldn't have performed this job from day one if he didn't have the qualifications. Because like I said, it was the same job that he was applying for. So we sent them the transcripts, letters from professors, letters from his previous employers who were in the same industry. and a letter from the petitioner explaining, look, he's very much qualified, he's been working for me, he's doing a great job, etc. In March 2020, the I-140 was denied again. And honestly, I forgot to mention one thing. When we refiled the I-140 as an amended, to avoid having that issue with the master's degree again, we didn't file it as an EB-2, we filed it as an EB-3, as a professional or a skilled worker professional. So you need at least a bachelor's for that. It didn't matter that he had the master's, it was kind of irrelevant now. So we didn't have that issue again, but it did get denied again. This time it said, again, what the RFE said, that he wasn't qualified and that his education alone wasn't enough. And they also, in the denial, ignored some evidence. So the problem at this point was that his H-1B was expiring at the end of March. And if his H-1B expired and this doesn't get approved, then he's out of status. Well, he was able to stay here while it was pending, while the I-45 was pending, even past March, the date in March that his H-1B expired. So we said to him, look, if we don't appeal this, we think they're wrong in their decision. They're legally wrong and factually wrong. But if we don't appeal it, you can try to do it again, but you're going to have to leave. So he wanted to appeal it. Well, the petitioner wanted to appeal it. And we had when you do an appeal, it's more than just a cover letter explaining things. You cite to the law and all that. So we basically said to them, look, here's proof that his education alone gave him the skills. We got his professor to say, here's what I've taught him, and he needs these skills to do those duties that you're describing. We also, I think we had to do what else? We also had to show them, like, they tried to claim that some of the letters that were in from previous employers weren't his supervisors. So even though like one was signed by the president of the company, we're like, that was his supervisor. So we had to get letters from the employer saying, look, I supervised him. I directly supervised him. And then we also had to point out that you denied this. You said we didn't submit certain evidence that we submitted, and then we had to resubmit it. So we filed the I-140 appeal in April of 2020. Less than a month later, hallelujah, it was approved. They agreed with the USCIS approved our appeal, remanded back to USCIS to approve the I-140. And then in July of 2020, they transferred his I-485 to the local office. He's waiting for his interview now. It hopefully will be any day, because now that they've opened up. But this case, this was a journey for sure. And I mean, when we finally got that I-140 appeal approved, I was ecstatic, because I had tried so hard for this poor guy every step of the way. Immigration, first they're saying that the job is too sophisticated. It's not sophisticated enough. He's too qualified. He's not qualified enough. It was like everything they could possibly throw at you, this guy had to deal with. And he finally, at the end of it, was able to get the I-140 approved. The green card, we're not worried. He has no criminal history, no immigration violations. We're pretty sure the green card part of the process will go smoothly. He's just waiting for his interview. So it just shows you that this is notable, like I said, for many reasons, and a couple of things to sum up, since there was a lot. The number one, you do take a risk if you have a non-immigrant visa and you leave the US when you re-enter. If they don't believe that you're re-entering for that same purpose, you might not get let back in. So that is a huge risk to take. Number two, they have been cracking down on H-1Bs, as we know, and this was even before the Trump administration. They've always been tough on computer professions, because there are a lot of professions out there that don't necessarily need a bachelor's or aren't so complex and unique. So you have to be ready, especially when you have a small company, because those are more likely to get audited in labor certification audits. They're more likely to get RFE'd when you're applying for H-1Bs. But as long as you really explain it to them and point out the law, like we always do, we're always able to get them approved as long as the person's qualified and the position qualifies. It's not a problem. That is all today for notable approvals. Like us, follow us on Facebook, YouTube, LinkedIn, Twitter, Gram, all of that, so you don't miss any more. I won't be here tomorrow. It is Friday. I'm just going to relax, but we will be back next week. Well, I'll be working, but we'll be back next week for another notable approval on Monday. And if you have any questions, comments, or concerns, please feel free to reach out to me. As you can see, this ticker on the bottom has been scrolling our contact information this entire time. We'll be more than happy to help. Thank you for watching, and we hope to see you soon.